All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Like I said, please be seated.
Sorry.
We are here for oral argument in 1 CACV 190045, Dinsmoor versus Phoenix. These proceedings are being audio recorded and video recorded, so we'd ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve any portion of that time for rebuttal. We've read the briefs. We've discussed this case this morning at conference. Mr. Abney, you may begin.
Thank you, Your Honor. May it please the Court, my name is David Abney. I'm here representing the appellants. Also with me today is my colleague, Ryan Skyver. Thank you for the opportunity to have oral argument. I fear it'll probably be a relic of the past where we're going to sequester everybody and quarantine everybody. But it's a good chance to be here today. The main issue, I believe, is duty, and my premise is very straightforward, that school districts do have a duty of care, and the trial court and the lawyers for the defense sort of fell off the edge of the world when they said there's no duty of care. There is a duty of care. The question really becomes one of what is the standard of care? Was there a breach of the standard of care? Proximate cause, foreseeability? All those things weren't decided at the trial court. The trial court just said, well, there's no duty. Anna was within the custody, care, and control of the school district, actually at the office, at the school's office, high school's office, just before she died, about an hour or so before. And she was there in a place where the school district could have fulfilled its duty of care to her by doing a number of things, contacting her mom, keeping her there, giving her a very, very firm warning instead of wishy-washy advice that might not be good to see this young man.
You're saying there would have been a basis for them to keep her there at the school?
Well, why not? They got her to the office. They didn't just say, well, wouldn't it be nice if you'd come by the office? I'm sure they directed her to come to the office, and she came to the office, she's there. If she tried to leave before school was over, they could certainly hold her there. And why not just extend the school day for her and hold her over? Or why not take her into protective custody? There's many, many things
What
that
had
could
she done wrong? I mean, you start talking about all of these things, but she did nothing wrong.
No, well, in the end, she did. She foolishly put herself in danger, and she got killed.
An hour after the school session ended and off campus. Now let's talk about you were talking about what she did to go to the office. Wasn't she just hailed into the office because she was a potential witness?
Well, she was there as part of the investigation because she had disclosed information that, in her view, Raven was in danger, that she had disclosed and explained before that she thought Matthew was crazy, that he had threatened to kill Raven, that he had a gun, he had access to a gun. You know, all these things.
Well, then I hearken back to your statement that they could have held her. What would they have held her for? She didn't do anything wrong. There was nothing to hold her for.
Well, she's a student under their care, custody, and control. She can't just wander off campus until school's over. They could simply declare for her, school's going to be extended a full day for you.
Well, okay, but you said they could hold her after the school proceedings had concluded, and that again goes to my question: what could they have held her for?
To protect her, Your Honor, as a student.
Oh, so she was subject to a threat.
She was proposing to deal with a young man who had made a death threat against her best friend, and who she said was crazy, and who she said was a dangerous person.
So she was subject of a threat? Was she threatened?
I do not believe so, Your Honor. And in
okay,
fact,
so you've admitted to us that she was not threatened. So what obligation did the school have? What were they obligated to do since she was not threatened?
there you've gone into standard of care, which is what the trial court did, and the lawyers for the defendants did too. It's not the standard of care issue. That's something for a jury to work through. What we're dealing with is the duty, and is there a duty to protect her?
And let's go back to duty, Mr. Abney. This tragedy happened off campus. Outside of school, outside of that kind of duty that we all agree, schools do have a duty to their students. This happened off campus. What is your opinion of the duty of care of a school when events happen off their premise?
It depends on the circumstances. The duty is to protect the student from harm. As far as fulfilling the duty, the standard of care, that's a different question. The relevant inquiry is always, where did the negligence happen? The negligence happened on campus in that office when she was under the care, custody, and control of the school district. At that point, the school district had a duty to act to protect her.
So are you saying that if there's no information that is available to the school during school hours regarding something that's going to happen after school hours, there would not be a duty? Or you're saying that's just independent of there's a duty to protect students in general, but it's simply not implicated?
The duty of care exists, but as far as what happens in the future, you're again, foreseeability, proximate cause, standard of care.
But a school district would have to go to trial. There's an accident, not an accident, but something that happens. There's gang activity on a weekend, and there's no evidence that, or there's just some rumors that there's going to be gang activity. But is the school district has to go through a trial when there's any information that the school was aware of it? The school district has a duty to the students, but if there hasn't been any information that's been provided to the school, they have to go through a trial on whether they carried out their duty to the student?
I would think not, but I would also think that the question answers itself. If there's no negligence at the school ground, and there isn't, I don't see any negligence on the school ground. And
how about just there were some rumors that there's going to be some gang activity on Saturday at the park? Does the school have an obligation to call parents and let them know that they've heard that there's an allegation that there's going to be gang violence?
And during school hours, the school learned about these rumors and did nothing? There again, I think the question answers itself. If there's negligence under those circumstances, there might be liability. The question is, where does the negligence happen, not where the end result happens. If the negligence happens on the school district grounds, then yeah, there
So,
could
Mr.
be
Abney, let me
liability.
make sure I understand your argument. Let me get this in real quick. You're saying that we look to the negligence to determine the duty?
No, not exactly. You need to determine where the school district learned whatever it learned in a situation like this, and it learned it on campus.
I understand that.
But the
We
duty
look
is
at-
there already.
So if the duty is there already,
Right.
why are we looking at anything that happens after that?
Well, the end result of any tort is the actual damage. The
I
beginning is the
understand that,
negligence.
but duty is a question of law that we look at basically in a vacuum with the information that we have, right? I feel like you're conflating duty and standard of care in the opposite way you're accusing them of. So let's talk about duty. What was the school district's duty to that student off campus? You think because there was information on campus, that duty extends to activities off campus, is what you're saying?
Well, in a way, yeah. If I try to, I hope I can define this a little bit better. The duty exists on campus, certainly. The student is right there in a place where she is, where the school district has a duty to protect her, to safeguard her, and does nothing. And then she leaves. Now, does the school district have liability? Has it breached its duty of care? Question of fact. If an hour later something happens that a reasonable juror could say, well, this was foreseeable. Proximate cause is obvious here. If they had just held her, if they had done this, that, or the other, she would have been protected. Then you've got the complete tort, but the duty is at the school district grounds.
So if this was Friday afternoon instead of midweek, and this happened Saturday evening, does the duty extend that far?
It would depend on the circumstances, and that's for a jury to decide. I'm trying to unconflate what's happened below. There is a duty. It's very simple, straightforward, well recognized here, and I believe in every jurisdiction in the United States. You have a duty to protect the student, to safeguard the student.
While they're on campus, and I don't think any of us disagree with that. What I'm asking you is, can you define how far that duty extends? And you're saying, look to where did the negligence occur? But what I'm asking is this. If if the school district has a duty off campus, how far and how long does that duty continue?
No, the duty is on campus. Whether there's proximate cause and breach of the standard of care, foreseeability, those are all jury questions. But here we have a clear case where there is a duty of care to protect, and it was breached. The negligence actually occurred at the school district when they didn't do anything before letting her go to combat what a jury could decide were reasonable indications of danger to Anna. It's hard to deny there was not some danger to Anna. She's dead in an hour. And of course, you may say to me, well, that's hindsight, Mr. Abney.
Hindsight is 20/20, Mr. Abney. This isn't as clear. If this had happened to Raven, not Anna, it would be an easier indication of duty. There was no direct threat to Anna.
No, but she gave, and both the girls gave information that this was a dangerous young man, that he was crazy, that he had made death threats, that he
So
had access to a gun.
what if he had shot somebody else, not either one of another student off campus an hour after? Was there an obligation on the school to warn every single student on campus that there was a crazy person that had gone to that school and they should be aware that they shouldn't meet up?
I do not know, Your Honor. I would suspect not. But here we're not dealing with the infinite population or a large population.
Well,
We're
how
dealing
far
with-
are we going to extend this duty of care? To every person that was in his sphere, Matthew's sphere?
No, Your Honor. But it extends to Raven. She's right.
Oh, clearly, she's
and
the subject of a threat.
Pardon me. It extends to Anna and Raven, but Anna's the focus here. She's right there. She is the school people, the police officer. They know that she regards this young man as crazy.
But there's testimony that she was not afraid of him.
Oh no, she wasn't. How nice to be 16 and think you can live forever and be naive as a doorstop. And that's why they have to protect her. She's a kid. She doesn't know any better. She may say, "Oh, I'm fine. I'm going to go. I get this image. I'm fine. I'm going to go talk to him, and everything's going to be fine." Well, you don't talk to crazy people when you're a kid. You just get hurt, and they should have known that, but they didn't do anything, and they could have. She's right there, and they have a duty to protect her, and instead, an hour later, she's dead. And they say, "Well, we didn't know anything." Well, Anna knew there was a problem. Raven knew there was a problem, but Anna had come up with a solution to go to talk to the kid. I mean, give me a break. Adult would not think that, and adults supervising children should not have thought that. Of course, those are issues really for the jury: proximate cause, foreseeability, breach of the standard of care. What is the standard of care? And like I'm saying, just trying to separate these and keep them as separate as they can be and should be, because the duty is there. Whether it's been a breach, whether there's proximate cause, those are issues for the jury.
Can I go back to my rather inarticulate hypothetical where there's, let's say there's gang activity that doesn't necessarily involve any student, just that there's gang activity that's going to be at a park. And the danger to students is just if students decide they're going to go to the park on Saturday when there's going to be some gang activity. Is that something that implicates any need for action on the part of the school?
It might under the proper circumstances. I mean, suppose the school knew that there was a coronavirus with certain students and they were going to get together to have a rally against oppressive quarantine measures at the park on Saturday. Who would think there's not a duty to say to the other students, keep away from the park? And here, if you know there's going to be gang activity and violence at a park, who would say there's not a duty to warn the students, stay away from the park? We want to protect you. We're a school district, and our duty is to protect you.
There's a dangerous highway. There've been a lot of accidents on the highway. We're going to tell students not to. We're going to expect a school district to say, "Don't drive on this road."
I think that's a bridge too far, Your Honor. But the example you gave, and I think it was very articulate, by the way, it's a logical place where you'd say there is a point here where the school district does have a duty to warn of general events it may know about. But here we've got much more specificity in what's going on. And the fact that Anna says, "I'm not worried about myself," that should have rung alarm bells in any adult mind. I think that the case that really helps us out here is NL, and I would ask the court to take a close look at it. I know it's Washington, and the duty of care in Washington is some sort
It's
of weird.
inconsistent with Quiros, isn't it?
Quiros. Now there's an interesting case.
Well, but before you get there, and I'll let you get there, but isn't that case inconsistent with Quiros?
No,
The Washington case.
no, because Quiros recognized several times that the common law can provide the duty of care, which common law, and they're talking about, I've always thought about this when these duty cases started coming down, that there's several firm sources of duty, statutes, public policy, if it's been recognized as public policy, and what I would call venerable or long-lasting common law principles. One of the most concrete principles in Arizona law has always been that a school has a duty to protect its students, and that has not changed at all. So I think Quiros is actually right on point as far as recognizing the existence of common law duties. Plus, it also recognized the undertaking duty. I think paragraph 66, 67 of the Quiros opinion deals with duty by undertaking. If you undertake to do something to protect somebody, then you have a duty to do it in a non-negligent way.
We're not in that box here, though.
We are in that box.
We are in that box. Isn't the box of the school-student relationship, isn't that enough of a box to create a duty?
It's a great box. But there's also a duty for the school district and for the police officer who was there to protect students because he was hired by the school district. They both there was some wishy-washy, namby-pamby, I don't know what adjective is right, efforts to warn Raven not to go there. Basically, make good choices, and maybe you shouldn't meet him. And that was an undertaking. It's what we ran.
But that's in the context of the person giving that advice wasn't aware of that Matthew was on campus with a gun, isn't it?
Well, there were rumors. Now, it turns out the rumors may have been false. But what you're dealing with at this situation is you've got rumors that he's on campus with a gun, and you've got knowledge that he has access to a gun. You've got Anna's.
But is that the type of undertaking to protect that would create a duty?
It's enough. It's enough. If you're giving advice to people about what they should do.
What's your best case on that? The ones I've seen are usually where someone has said, "We will protect you," kind of thing, where somebody calls in with a threat, we'll send someone to protect you. I'm not aware of cases that are this tangential, and I'm not sure we need to go there when you have the duty box of the school-student relationship.
Well, I cited a number of cases in the brief, Lloyd, for instance, and in a way, Austin is an undertaking case as well. Austin versus City of Scottsdale police undertaking case. I mean, all the police dispatcher did in that case was to look in a phone book and couldn't find the name of the proposed victim and just said, and went on with their day. But here we've got more. We got giving advice to Anna about what she should do. They should have done a lot more, but they started. This is like what we ran into in law school. Maybe you did. Professor Dobbs used to say, at common law, you're walking past a pond and there's a child drowning. It's not your child. It's not a child you have any dealings with, any custody or anything. You can walk on by and let the child drown. No duty. But once you leap into the pond to try to rescue that child, if you do the rescue negligently, you've got a duty of care. If I may reserve my remaining time.
All right. Thank you, Mr. Abney.
Thank you.
Good morning. My name is Brad Jardine. I'm pleased and honored for the opportunity to represent the Deer Valley Unified School District. Between Ms. Burke and myself, we've decided that I will go first and then she will follow. I'm also grateful for the opportunity to represent the district because both my parents were teachers, and I honor and respect those to whom we trust our students and our children.
Let's talk about that trust. Let's talk about the duty a school district or a high school owes to its students.
Pleased to do so.
How far do you believe it's ever available, that duty of care, or well, the duty, does it extend beyond school hours? Does it extend beyond campus? And if so, when does that end?
I'm going to give you two answers. The first answer and the clear answer to your question is answered in this court's decision in Monroe versus Basis School, a decision out of 2014, where this court indicated and held that where a duty arises from a special relationship, and there's no question that a student-school relationship is a special relationship, as defined by Quiros and a number of other decisions, that duty is tied to expected activities within the relationship, quote, In the student-school relationship, the duty of care is bounded by geography and time.
But it doesn't Monroe just involve an accident that occurs after school?
Yes.
But isn't that very different than the question here would be, did you become aware of information that at a minimum a parent wouldn't want to know? And so you became aware of this information, you're sort of filling in the role of a parent. That's part of this. You're in this duty box because you have a school-student relationship, and you become aware of information that every parent in the world would want to know. Let me go, the hypothetical I would give is, you're aware that the student is going to cross the street and someone has threatened to shoot them 5 minutes after school across the street. So it's not going to happen on campus, but you become aware of that. Are you suggesting there's no duty there?
That, again, is going to depend upon more facts than I think than you have
No, but
given us.
these are the facts, but under those facts, you become aware, someone reports a threat that a student is going to cross the street and 5 minutes later is going to be shot by somebody. It happens off campus. So, I mean, under the rule that it's not happening on campus, that you're suggesting there's no duty to do something.
I am not. Your question is referring to a victim who is the target of the threat. We are here dealing in this circumstance with a young woman who was never the target of a threat. And there is no, to answer the question, there is no policy, nor regulation, nor requirement under common law or otherwise to advise the parent of a student who's reporting conduct but whom is not the target of the alleged threat.
Why isn't there a fact question as to whether this particular person is at risk?
Precisely for the question that was asked by this court, I apologize, I don't remember which one of you asked the question. The question was, to whom do we extend that responsibility? If there is a threat of a person who is going to commit some bad deed, to whom then does that duty extend? Do we call all the children or all the parents of all the students who are there?
But doesn't that just go to the reasonableness of how you're carrying out your duty?
It could, but that also depends, as we indicated in our brief, that this court has the responsibility to set limits under the causation, because if I think the example we used had to do with lockdowns and things like that. Do you always call every parent of every student who might possibly be involved with this circumstance? It is the responsibility of this court to set those outer limits. We briefed that, we said so in our brief, but we're dealing here with Anna. As tragic as this circumstance is, she was not the target. She was not the person who was targeted by this threat. And she knew that.
But she's part of it. It's a small group. It's a small group of people who are presumably involved in the altercation. There's Anna and Raven and Matthew are kind of at the center of this dispute. We're not talking about every person in the school, but certainly the relationship between Anna and Matthew, Raven and Matthew, and Raven and Anna is what seems to be precipitating this dispute, or at least the threat to Raven. It seems like isn't there at least a fact question as to whether Anna there is some danger to Anna? Why isn't that a fact question that's apart from I think you're agreeing with me that there is a duty that's owed to students in general.
Within time and boundaries, absolutely,
But this is
as in the Monroe case said.
Okay,
and Colette
and so here
forth.
you would agree that if there's a threat that they become aware of, that someone is going to shoot Anna 5 minutes after school across the street, then there's a duty and they need to do something, whether it's call Anna's parents.
Oh, I would agree with that. That's not our case, but I agree with that.
But why isn't it then simply a matter for the jury to decide whether this was enough information that the school district should have? And I'm not saying that it necessarily follows that they should have done something different than what they did, but this is a pretty narrow group of people that are involved. And couldn't a reasonable parent or a reasonable jury conclude that under these circumstances, at minimum, these two parents should have been contacted.
My response to that goes back to actually the Markowitz decision and those decisions that have flowed from it, including some by Judge Fidel in Rogers versus Retram and others, where this court held that under certain circumstances, there can be no liability if no duty exists, even if there is negligence.
But you're agreeing there's a duty to protect the
No,
student.
I am not agreeing that there is a duty to protect Anna because Anna wasn't the target of a threat. I am agreeing, I'm stating that there is no
But
responsibility
you're
and
saying there
no
was no
duty.
threat to Anna, and my
There was
question
not.
is, but couldn't a reasonable juror disagree with you on that? Isn't that the point of having a jury decide whether there was in fact a threat to Anna? I understand there's not a direct, someone is going to shoot Anna after class, but would you agree that there are circumstances under which we could say more than just Raven is at risk based on this conduct?
Potentially, but it still doesn't get away from what Judge Fidel and numbers of other cases in this court have held, that there cannot be a negligence, there cannot be liability, even if there's negligence, if no duty is owed in the first instance. And that's where we are here. We're dealing with a circumstance where an incident occurred over an hour after this school ended, at geography that doesn't have any relationship to the school, by individuals who have no connection with the school. And so therefore, even if you say that there is negligence because maybe there should have been some contact.
Under your argument, though, you're saying my hypothetical with this threat to something that's going to happen 5 minutes after school across the street. The geography, it's not on school grounds, and it's after school hours. And that seems to me different than whether there's a duty. The duty is to do something that you become aware of during school hours. And
Judge, I think I agreed with you that would there be a duty to that individual where there had been a threat to harm that individual 5 minutes after school's out? I agreed with you that there would be a responsibility.
the basis you're saying that the geography somehow matters, and that's what I'm pushing
It
back.
matters according to Monroe, and it matters according to the statutory scheme that we have cited to this court. It matters to Collette.
But you're saying it doesn't matter where there's been a direct threat to someone that's going to happen off campus.
It's an interesting discussion, but we're not there. That's not our case.
Well, isn't the answer that there's a direct threat on the campus?
Yes.
And therefore, that's where the duty arises, and then
Yes.
the fact is carried off outside. But
Precisely.
when there is not a direct threat on the campus, there is no duty.
Precisely, that's not our case. Exactly right. There was no threat to Anna. It wasn't made on campus or off
I
campus.
guess I just have a hard time saying there's no duty, because I'm reading Kiros and these other cases as saying duty, you can't create duty based on foreseeability. But,
Correct.
But if you have a separate box that's already there, the school-student relationship, there's a duty. And what you seem to be, where at least the way I'm interpreting it, that just, the argument you're making goes to whether they carried out their duty reasonably. And you may have a very compelling argument that they did, but I'm not seeing it as removing the duty that you had once you've learned about information while the student is on campus. And there may have been something that you can do while the student is on campus, whether that is, I'm not necessarily agreeing that you can hold somebody there, but maybe it's calling a parent.
Judge, with all respect, there was no threat to Anna on campus.
But that's your interpretation of the evidence.
I thought Mr. Abney conceded that there was no threat towards Anna.
He did.
But I don't think he conceded that she wasn't in danger.
I don't know that he conceded that. If he didn't, he should have. Because that was the finding of the extremely thorough trial court analysis
Yeah, but
and
we
review and order.
We review it de novo, but
Correct.
the concession was there was no direct threat to Anna.
Correct. That is correct. I'm sorry, I have a lot to say. I'm out of time. I need to give that time to my colleague.
All right, thank you. Ms. Burke.
Good morning, Your Honors. May it please the court. My name is Lori Burke, and I'm with the Burke Law Firm, and I represent the City of Phoenix and Officer Kenneth Palmer, who's here in the courtroom today. The issue of duty as it relates to police officers is very clear, and we need to look no further than the Noriega case and Quiroz. And what those cases say is that we do not look at facts. When Mr. Abney was up here, every question he was asked about duty, he turned to the facts of the case. And duty in Arizona, as we all know from Quiroz, is not fact-driven. The issue of whether there's a duty is determined at the outset without looking at any of the facts of the case.
Is there a question as to whether Officer Palmer was under the supervision of the school?
He was not.
But wasn't there a concession at some point that there is some sort of relationship with?
He was
the school?
He was hired as a school safety officer, and under the contract that's in the appendix, his responsibilities were to be a law enforcement presence to hopefully deter crime, to handle criminal matters, and it's expressly stated in discovery responses from the district, in his testimony, and the training materials that are part of the record for school safety officers, that he is, and the City of Phoenix operations order, that he is prohibited from assisting in enforcing school policies. He is there solely as a law enforcement officer, enforcing and carrying out the laws of the state. And so we look at whether there was a special relationship created between Officer Palmer and Anna, and there was not. In the Noriega case, it states, quote, "A special relationship is created and thus a duty of care owed when police officers learn of a potential threat and tell the victim that they will take action on that threat." Neither of those were present here. Mr. Abney acknowledged that there was no threat to Anna, and Officer Palmer, who didn't perceive there to be a threat either, made no promise to protect her because he felt there was no need to do so. So we don't have a special relationship created, and there's also no statute that would create a public policy duty, and therefore there is no duty at all. Mr. Abney spends the majority of his answering brief arguing voluntary undertaking of a duty, and that's not present either. He solely bases that on a statement that Officer Palmer made to Anna when she told him toward the end of the day that Matthew and her were possibly going to have a conversation after school. And Officer Palmer just remarked, "There's no need for you to meet with him." And what Officer Palmer testified to is that when he made that statement, he was just thinking, "You're not dating him anymore. There's no reason for you to be talking to him." He did not perceive there to be any threat, and that was not a voluntary undertaking as that is defined in the law. If you look at the Quiroz case, voluntary undertaking is specifically addressed, and it states that a duty based on a negligent undertaking does not arise solely because a defendant committed an act that might harm someone. Rather, a duty based on a negligent undertaking exists when a person who otherwise owed no duty to plaintiff voluntarily agrees to provide services for another person. Under such circumstances, the person assumes a duty to exercise reasonable care. Officer Palmer did not volunteer to provide services to Anna in any respect. The examples that the cases give are where a radiologist is hired by an employer, and this is in the Quiroz case, I believe. A radiologist is hired by an employer to review a job applicant's x-rays for a pre-employment exam. That radiologist assumed a duty of reasonable care. In the trying to remember what that case is. It's State Farm's the appellee, and it's cited in the materials. I just can't remember the first name, but it's State Farm is one of the parties. The issue, it was a bad faith case, and the issue was whether the insurance company had assumed a duty to defend its insured. And State Farm had said, their insured, will take care of it, and then later tried to get out of the duty to defend. And the court said, no, you voluntarily undertook to do that. And other examples of.
Can I ask more about, I'm more interested, I think, in whether the officer was acting as an agent. It seemed like the disclosure statement said that he was acting as an agent for the school district. Why isn't that enough to at least create a fact issue as to whether he was an agent or not?
But only in a law enforcement capacity. So first of all, that's not a judicial admission. That's certainly.
But you would agree it's evidence.
It's evidence, sure.
But so if it's evidence, why can't a jury just consider it?
Because I don't even think we need to get there. His only duty, even if he was an agent of the district, is to provide law enforcement services. The scope of his agency is based on the contract between him and the school district, which is in the appendix. And it clearly sets forth what his duties are, and none of them entail carrying out policies and enforcing policies of the school district, even if he's an agent of the school district.
But if he's an agent, why isn't there at least a fact question as to whether acting in that agency role, he gave the school enough information for them to respond reasonably?
Because you have to look at what the scope of the agency is. What does the contract say? The contract says he is only there to provide law enforcement services as a police officer. And he is not to be involved in enforcing policies, carrying out policies. Plaintiff's own experts, and we've cited this testimony in the materials, testify that Officer Palmer had no responsibility to call Anna's mother.
But I think the argument that they would be making is that there's a responsibility to thoroughly investigate. And if there's some suggestion that it wasn't thoroughly investigated, he's acting as an agent, that has nothing to do with carrying out district policy. And I'm not saying there's compelling evidence that he did something wrong, but that their argument is you're an agent of the school, and if you don't do the investigation, that's on the school. Let's say he didn't interview anybody, and he told the school that he had in fact interviewed people. Is that not something a jury could take into account and say the school's own agent said he interviewed people, but he in fact didn't interview anybody?
But that's not a duty owed to the student.
But he's an agent of the school, and that goes to whether the school's duty was carried out.
Well, that would be an issue that goes to the liability of the district. But his only responsibilities are law enforcement responsibilities, and he doesn't owe a duty to Anna.
But let's say he's a teacher, and the teacher says, I investigated something, and the teacher just lies and didn't actually question anyone. Is the teacher's not part of the litigation under those circumstances?
That would be an issue for Mr. Jardine to address as to the issues of issue of duty of teachers and what's required of them. But Officer Palmer had no responsibilities to teach, to do anything that a teacher would do.
Let's say he's just an investigator that the school district has hired, and he's not affiliated with any police agency.
But it's still not a duty owed. That would be, I guess, a third-party beneficiary analysis, and none of the students are designated as third-party beneficiaries in the contract between Officer Palmer and the school. The school could certainly terminate his employment, but whether he's an agent or not doesn't establish a duty on the part of Officer Palmer to Anna.
All right, thank you, Ms. Burke.
Thank you, Your Honor.
Mr. Abney, any final word?
May I have an additional hour to address?
The request is denied.
Thank you, Your Honor. You're right, there was no direct threat to Anna, but that does not mean she was in danger. She was in extreme danger, And Anna and Raven between them have provided enough information, plus the rumors and reports of the gun and Matthew on campus, whether or not true, it's enough to influence what and direct what the school district and the police officer should have done. And that, of course, gets into standard of care, breach, proximate cause, all of those things that are the next step after you decide if there's a duty. And here the decision on duty is fairly straightforward. Arizona common law across the nation, common law going back centuries, is that school districts, schools, have a very special relationship with the students and have a duty of care to protect those students. You asked earlier, Judge Catani, if this was the sort of information a reasonable parent would want to know. You bet. You'd certainly want to know about this kind of information because it sets off alarm bells. I think I've fallen into a trap, and my colleague Ryan Skyver was writing me notes to remind me about this, of sort of taking a little too lightly the relationship between these three people. He calls it a love triangle, and I sort of scoff because they're young people, and I'm getting old, and I can't remember the passion of my youth. But one of the greatest experts on child psychology in the world, William Shakespeare, wrote a play about this, about how emotions and love at a young age can just make people do the craziest things, suicidal things. Romeo and Juliet was 13, and Romeo was 14. And here we've got a student that's 16, Matthew Bolton, and another student who's 15, and Raven's young, and they're all trapped in this sort of what we might view as a logical, emotional relationship where they're angry at each other, they're saying hateful, dangerous, threatening things about each other, and then they act on them. And we sort of put that down as you've got to be kidding me. People wouldn't do this. Well, people do this, and it really at a young age. Here, it ended in death. And it should not have, reasonable jurors could say. Something should have been done to protect this young woman, and nothing was. But the duty of care is very clear, very straightforward. As far as the police officer being an agent, well, they hired him to protect the students. I've used up my time, I believe. Thank you very much for your attention.
Thank you, Mr. Abney. The matter will be deemed submitted. We'll issue a decision in due course.